already answered. I
Sorry,
have
my
passed
lord.
that stage. I'm at the stage of recording appearances. Any appearance for the defendant?
My lord, I saw him online a short while ago. I don't know why he's offline now.
Well, I don't know. He is not online now, so he is absent.
Yes, my
This
lord.
matter is
My lord,
yes.
VN1 call announce appearance for the defendants, my lord.
They have announced me not online. Now, you can see you're online now. They say they are fine with you.
This matter is for judgment. The
We didn't have
judgment of the
any.
court is ready, and it will be shortly read out.
Yeah, we can record it.
This is the judgment of the court. The claimant took out a general form of complaint dated 1st of March 2023 and filed on the same day, accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be tendered in evidence at the trial. The originating processes commencing this suit was amended with leave of court on 29th day of November 2023. By the amended statement of facts, the claimant claims the following reliefs. The reliefs have been captured, so I will skip reading the reliefs. The claimant testified in proof of his case as CW1 after identifying his witness statement on oath adapted same as his evidence in this case. He also tendered Exhibit C1 to C9. The first defendant testified in defense of the defendants and tendered two documents
Online.
which were marked as Exhibit D1 and D2. The case of the claimant, I will skip reading the case of the narration of the case of the claimant. The case of the defendant, I will also skip reading the case of the defendant. There is the submissions of the defendants where two issues were formulated. The issues and argument in respect of the issues have been captured in the body of the judgment. So I will skip reading the submissions of counsel. Then goes to the submissions of the claimants. The submissions of the claimants where the submissions have been captured in the body of the judgment. So I will also skip reading the submission of counsel regarding the case of the claimant. I go straight to the decision of the court. I have carefully considered the processes filed in this suit, the evidence adduced at the trial, as well as the written and oral submissions of the parties, counsel for the parties. The task to be performed by the court is to examine the processes and evidence adduced by the parties vis-a-vis the law applicable to the facts and see if the claimant has been able to establish entitlement to the relief sought. Before proceeding with the determination of the dispute submitted before the court, I shall at this juncture endeavor to thrash out the issue of jurisdiction of this court to hear and determine the suit raised by the defendants in their defense and final written addresses. This is because jurisdiction being a threshold matter must be determined before the court can proceed to deal with the substantive complaint of the parties before it. Where jurisdiction is absent, whatever the court proceeded to do, howsoever elegantly done, amount to a nullity and waste of precious time, and ultimately void. The issue of jurisdiction is fundamental one that goes to the root of the foundation of the matter. It is a paramount importance to any adjudication, and the matter and must be considered first to avoid incident of futility in situation where a court wrongly exercises jurisdiction over matters which it has no bias. This explains why issue of jurisdiction can be raised at any time in the court of first instance, the court of appeal, or at the Supreme Court for the first time. See the case of Attorney General of Anambra State and Attorney General of the Federation. See also Barclays Bank of Nigeria Limited, Nigeria versus Central Bank of Nigeria. See also Dangana versus Usman. See also Usman Danfodio University versus Kraos Temples Organization Limited. Courts being creators of constitution or statutes have their jurisdiction delineated by the constitution or the statutes that created the court. That will also confer jurisdiction on that court. It is only by amendment of the constitution or the statute that the legislature can increase the jurisdiction of the court or decrease same. See the case of Okulate versus Awosanya. A court is competent when it is properly constituted as regard members and qualification of the members of the bench and members is no member is disqualified for any reason or the other. And two, the subject matter of the case is within the jurisdiction and there is no feature in the case which prevented the court from exercising its jurisdiction, and the case comes before the court initiated by due process of law. The case initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. All these three requirements must coexist conjunctively before a court can be said to have jurisdiction and to have jurisdiction. It therefore means that where a court has no jurisdiction to hear and determine a case, but goes ahead to do so, it engages in exercise in futility, as the decision arrived at in such a case amount in law to a nullity, irrespective of how well proceedings were conducted. See the cases of Madukolo versus Nkendile, Sken Consult versus Kondiupi, Benin Rubber Production Limited versus Ojo, Nefa versus Honor, Emeje versus Positive, Umbadi Naju versus Ezuka, Duke versus Akapabio local government. Therefore, jurisdiction of court is determined by claim of the plaintiff, by the claim of the claimant, and not by the defense. And so, in the case at hand, it is the complaint and the statement of facts which contain the relief sought by the claimant that will be considered, and the document attached therein that will be considered by the court in coming to the conclusion whether it has jurisdiction or not. Therefore, the determinant factor as to whether or not a court is seized of jurisdiction is the claimant's claim, which is the initiating process. In determining jurisdiction, the totality of all that constitutes the claim before the court are the relevant material and must be taken into consideration for purposes of ascertaining whether or not subject matter of the case is within the jurisdiction of the court. It is a matter of fact, objective in nature, and which does not take into account defense of the action. Jurisdiction as the life wire of threshold of education, a court can neither close itself therewith where none exists, nor can it be conferred by consent of the parties or counsel. See the case of ANPP versus Goni. In the amended statement of facts, the claimant in this case is seeking for grant of several reliefs. Reliefs A, B, and C are the main reliefs being sought by the claimant, while reliefs E, F, G are ancillary dependent on the grants of the main reliefs. It is clear from the reliefs being sought by the claimant and the fact pleaded in the statement of facts, the claimant is complaining about purported removal of his name from the board of directors and employment of the second dependent, claiming that he is still an employee of the second dependent entitled to be paid all accrued 1% global profit made by the second dependent, 1,200,000 naira being accumulated monthly remuneration from July 2022 to February 2023, when the matter was instituted in court. Payment of 150,000 naira monthly from March 2003 till the final judgment is given. The remaining reliefs borders on cost, damages, and interest. It is clear to me from the relief sought and the pleadings of the claimant that claimant is challenging removal and payment of 1% global profit as director and employee of the second dependent. The question whether a company is also an employee, the question of whether a company director is also an employee under Nigerian law has long generated doctrinal and practical controversy. Practical controversy under the Companies and Allied Matters Act 2020, the directors of companies occupy a unique position in corporate structures as they are entrusted with management authority and fiduciary responsibility. Yet, many directors, particularly executive and managing directors, perform operational roles traditionally associated with employees. This dual status raises fundamental questions concerning employment protection, procedures, termination procedures, entitlement to benefit, and pension rights. Under the under the Nigerian law, under the Companies and Allied Matters Act, directors of companies are traditionally regulated by under the Nigerian law. Companies directors are traditionally regulated by the Companies and Allied Matters Act 2020, while employees are regulated by common law. By common law, the Labor Act, and other employment legislations. See the case of Yalaju versus Amaye, Yalaju Amaye versus Associated Engineering Professionals. See also Section 269, subsection 1 of the Companies and Allied Matters Act, which define directors as persons duly appointed by the company to direct and manage the businesses of the company. The term includes any person occupying the position of director by whatever name called, and includes any person in accordance with whose directives and instructions the directors of the company are accustomed to act. See Section 861 of KAMA. The praise by whatever name called include all classification of directors, such as executive directors, non-executive directors, independent executive directors, managing directors, etc. For purposes of their removal under Section 261 of KAMA, all directors, whether executive or non-executive, are the same as long as they are engaged to direct and manage the businesses of the company. See the case of Longe versus First Bank of Nigeria. First Bank of Nigeria. By Section 305 and 306 of the Companies and Allied Matters Act, directors are fiduciaries and agents of the company, and all duties of loyalty, of care, skills, and good faith. Generally, their position is that of control and governance rather than subordination. Nigerian courts have consistently held that appointment of director does not by itself create a contract of employment. See the case of Yalaju Amaye versus Associated Registered Engineering Construction Limited. In this case, the Supreme Court emphasized that directors of a company are trustees, agents, and fiduciaries of the company. However, under the Labor Act, a worker was defined as a person who works under a contract with an employer, whether the contract is for manual labor or clerical work, but it does not include person exercising administrative, executive, technical, or professional function as public officers or otherwise. See Section 91 of the Labor Act. Going by the Labor Act, a director appointed under KAMA may not be employee of a company. However, the modern way of looking at status of director is to use rather than title, post, or position held. The the common law approach by focusing on the factual existence of a contract of service and nature of the relationship rather than the title, the given title, position, or post being occupied by the said director. This approach is in tandem with ILO jurisprudence, with emphasis that principle of primacy of fact. The principle emphasizes that existence of an employment relationship should be guided by the facts of what was actually agreed and performed by the parties, and not by the names they have given the relationship. See the case of Shena Security Company Limited versus Afropact. The question of whether this court has jurisdiction to entertain this suit will depend on the finding of whether a director is an employee of the company. This will be revealed by the facts of the case, i.e., whether the director, apart from his appointment as director, also has a contract of employment or service contract with the company. By the provisions of Section 288, subsection 2 of KAMA, it has recognized dual capacity theory, which enabled director to hold dual capacity as director and employee status simultaneously at the same time. This was firmly entrenched in the case of Lee and Lee Air Farming Limited, an old English case. See also the case of Iwachuku versus Unwizo and another. The above authorities show that a person may hold the position of director while he enter while also entering into a contract of employment with the company. The director's fiduciary obligation arises from statute, the corporate governance norms, that is the Companies and Allied Matters Act, while his employment relationship arises from contract and labor law. Further support for recognizing dual capacity theory could be scooped from the cases of Longe versus First Bank of Nigeria PLC, Iyalaju Amaye versus Associated Engineering Supra, and the Court of Appeal case of Olarewaju versus AfriBank. In these cases, the appellate courts recognize that a director may also be an employee, where a separate contract of employment exists between the company and the director. This means a director will have his employment subject to corporate law and labor law. This court has evolved a simple formula by way of question and answer to determine the court with jurisdiction in this type of cases. In Oebaji versus Julius and others versus Shell Petroleum Limited Company, suit number NICN/LA/648/26, decided by the president of the court, has this to say: what legal rules will apply in resolving the issue at hand? If it is labor law or employment law rules, then the National Industrial Court will assume jurisdiction. But if it is some other rules of law, then most probably the National Industrial Court have no jurisdiction. Applying the above formula in this case, in resolving the issue of jurisdiction, I would like to straight away say that, having regard to the reliefs and pleadings of the claimants, as well as Exhibit C1 and Exhibit C2, which form the fulcrums of claimant assumption that he is an employee of the defendant, one would be right to say that Exhibit C1 clearly shows that it is not a letter of employment based on labor law or common law guiding contract of service. The reason being that employment is determined by existence of a substance of a contract of service rather than by a formal title or post of office. Thus, why the court is guided by a number of factors in determining existence of contract of service, such as intention of the parties, remuneration, mutual obligations, degree of control, and integration into the organization. See the case of Shena Securities versus Apropat. In that case, the Supreme Court emphasized that the totality of the relationship between the parties are determined by status of employment. In view of the foregoing and having regard to the totality of the reliefs being sought by the claimant in this suit, it will be correct to come to the conclusion that Exhibit C1 is not a letter of employment capable of creating a contract of service between the claimant and the defendant because it is in deficit of the factors that point to the employment status being created as per the case of Shena Securities versus Apropa for service rendered under the Nigerian jurisprudence. An employer is duty bound to pay employee agreed wages as consideration for service rendered by the employee. In Mobile Producing Nigeria Unlimited and another versus Udo, the Court of Appeal, par Omokri as his name was, observed that it is well settled in the contract of employment that service and wages are the twin pillars upon which the contract rests. The absence of provision for wages in Exhibit C1 and the provision of 1% profit turnover point directly to Exhibit C1 being an offer for a director. It's strictly in a corporate governance capacity. The absence of provision for payment of regular salaries or wages, which is the fundamental pillar of a master and servant relationship in employment under the Nigerian labor law, an explicit statement that the appointment is not salaried, which was stated in Exhibit C1, means that no salary will be paid, strongly negates an employment relationship as per Exhibit C1. The provisions made in Exhibit C1 for global turnover share of 1% goes to show that the provision is for a director's remuneration or a profit sharing incentive, not an employment salary or wages. Under the Companies and Allied Matters Act, the directors can be remunerated via a percentage of company turnover or profit if authorized by the companies and article of association or at the general meeting. The provisions of out-of-pocket expenses contained in Exhibit C1, which means reimbursing a director for expenses incurred while undertaking company assignment is standard corporate governance practice. It is not an employment benefit, but rather an indemnity for carrying out official board duties. The work schedule, as can be gleaned from Exhibit C1, prescribe prescribed for the claimant, i.e., advising the company as a board member, attending board meetings, projecting the image of the company, representing her whenever the need arises, ensuring the interest of the company is protected at all times, and availability to carry out other miscellaneous duties that may arise from time to time on behalf of the company, and carrying out research clearly described fiduciary duties outlined in sections 305 to 309 of the Companies and Allied Matters Act. These are duties an officer owes to a company by law, not an employee operational job on daily operational job descriptions. Miscellaneous duties like research do not do not change this, as director frequently conducted strategic analysis for board decisions. The provision contained in Exhibit C1 stating that the appointment of claimant is subject to the decision of the company mirrors the corporate right to remove a director, while in employment contract there is the requirement for strict adherence to procedures for determination of a contract. Applying the control test to see whether Exhibit C1 can confer employment on the claimant, it must be to indicate claimant is subject to the strict control and daily supervision of the employer. However, the facts as disclosed by the pleadings and Exhibit C1 clearly depicted failure of the integration control test, and the claimant's duty of advising the board, protecting company interests, attending meetings, unequivocally shows claimant is part of the governing mind of the company, not a subordinate integrated into the daily workforce of the second dependent. In view of the foregoing analysis of Exhibit C1 and the pleadings of the claimant, I came to the conclusion that in the absence of a separate distinct contract of a service, the claimant action can only be determined using Companies and Allied Matters Act, and not employment rules and regulations or law regulating employment in the circumstances. This court lacks the requisite therefore this court lacks the requisite jurisdiction to hear and determine this suit, which borders on removal of director and claim respecting 1% global profit, as these are questions fit for determination by a Federal High Court pursuant to the provisions of Section 251 of the Constitution of the Federal Republic of Nigeria as amended. If the matter before if the claimant case is only for claiming for salaries as employee, this court would have assumed jurisdiction. In view of lack of jurisdiction by this court to determine the claimant claim, I hereby pursuant to Section 224, subsection 2 of the National Industrial Code Act, order transfer of this case to Federal High Court, Calabar Division, for hearing and determination. I hereby ordered accordingly that this case be transferred to Federal High Court for determination. The registrar is hereby accordingly ordered to carry out the directives of the court. The judgment is hereby entered accordingly.
As the court pleases.
Lord, we are grateful for the well-considered judgment. Thank you, and we wish you more years in the legal practice, and ask God to bless you as you leave us. And thank you, my Lord.
You. You are welcome. Yes, registrar, call the next case.
Yes, my lord. Claimant, defendant, please, if you're online, answer. Suit number NICMC A56-2025 between Mr. Adefowowe Adebamuwo.
Present. Present.
Yes, claimant in court.
Present.
And Sterling Bank.
Present.
Yes, you have been noted.
Sterling Bank Limited.
Absent.
Yes, ma, the defendant is absent, my lord.
Okay, appearance.
May the court be pleased, A.G. Robert for the claimant.
Yes, any other appearance?
May it please my lord, Ekpedeme Iyoro for the defendant. Iyoro is IYOHO. Ekpedeme Iyoro. Iyoro is IYOHO.
I have recorded you. Yes, this case is for judgment. The judgment of the court is ready. The judgment goes like this. On 31st day of October 2025, the claimant commenced suit bear a general form of complaint accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be tendered as exhibit at the trial. The claimant by this action is seeking for the relief set out as follows in his paragraph 73 of the statement of facts. I have captured, I reproduced the reliefs being sought, which are 26 in number in the body of the judgment. So I will skip reading the reliefs. I will skip reading the reliefs. On 6th day of July 2007, claimant was employed. Okay. The case of the claimant. I will also skip reading the case of the claimant. I will also skip reading the defendants, the case of the defendants. I go to the submissions of the defendants where two issues were formulated. I have captured the argument on the two issues in the body of the judgment. I go to the submissions of the claimant, The claimant counsel formulated 3 issues. The argument on the 3 issues have been captured in the body of the judgment. The defendant also filed a reply on point of law respecting the claimant's final written address. That has also been captured in the body of the judgment. So I will go straight to the decision of the court. I will go, yes. Court decision. I have considered the processes filed by the parties, the evidence adduced at the trial, as well as written and oral submissions of counsel for the parties regarding the position of their respective clients. In the final written address of the defendant, 2 issues were formulated for determination, while the claimant formulated 3 issues for resolution. The claimant's case is principally for wrongful dismissal from service and payment of gratuity before payment of pension and gratuity. Before proceeding to determine the substantive claim before the court, it behoves on this court to first and foremost thrash out objection of the defendant claiming that this suit is statute barred in as captured by paragraph 8 and 19 of the statement of defense, where the defendant asserts that the suit of the claimant is statute barred. Argument in support of the assertions on statute bar has been canvassed in the final written address of the defendant under the second issue for determination. The defendant, through her counsel, has argued that the claimant's case is incompetent as it is caught by the provision of section 16 of the Cross River State Limitation Law, which requires an action in contract or tort to be instituted within 5 years. According to the defendant, the claimant action is in all ramification cannot be maintained in law. The defendant urges the court to dismiss the claimant's action as he has lost the right to enforce his cause of action because the case was not commenced within the period stipulated by the statute of limitation. In his final written address, the claimant dedicated issue 3 to argument in opposing the submissions of the defendant on statute bar. The claimant insisted that his suit is not statute bar as it was argued for the claimant that his cause of action arose when he was discharged and acquitted as per Exhibit H in the judgment of the Federal High Court, that is on 29th of June 2022, September 2022. According to the claimant, time started running for the purpose of limitation law as from 2022 to 31st of October 2025, when this suit was filed before this court. This means from the date of accrual of cause of action to when this case was instituted on 31st day of October 2025 is a period of 3 years, 1 month, which is within 5 years provided for in section 16 of the limitation law of Cross River State for an action or matter to be instituted. The claimant further argued that the limitation law is not applicable to the contract of service. He further stated that even if this suit is caught by limitation, it is within the exception as his suit is that of continuance of damage or injury. He also argued that the claim for gratuity cannot be caught by limitation law. For the pleadings and evidence before the court, the main claimant's claim borders on propriety of his dismissal from service before he was queried or tried by a disciplinary committee and found guilty as provided by in Exhibit M, the employee handbook, which contained the terms and conditions of his service and thereby violated his right to fair hearing. It is also submitted that the defendant, having reported the claimant to the police for criminal investigation and prosecution, must not take any action leading to his dismissal until conclusion of police investigation and prosecution before a competent court of law. Therefore, for claimants, limitation law cannot operate until after conclusion of the criminal trial. It should be noted that the purpose of limitation law is meant to prevent stale action or situation of falling into deep slumber, thereby occasioning loss of evidence due to time lag. Where statute has provided period within which an action can be commenced, proceedings shall not be brought after the expiration of the prescribed period. Any action instituted or commenced after the period prescribed for its commencement will be statute bar. See the case of Ibrahim versus Kaduna State. See also section 16 of Cross River State limitation law, which provide, I quote, no action founded on contract, tort, or any other action not specifically provided for in parts 2 and 3 of this law shall be brought after the expiration of 5 years from the date on which the cause of action accrues. The provision of section 16 of the limitation law of Cross River State clearly prescribe 5 years period within which an action founded in contract should be instituted, or an action for recovery of any sum under any enactment. This means the claimant's action can only be held to be valid, brought before the court if and only if it is instituted within the period stipulated in the statute of limitation. In ascertaining whether an action is statute barred, the court looks at the date when the action was instituted and the date when the cause of action arose. Thus, the determination of whether an action is caught by a statute of limitation is a matter of calculation of raw figures, and a court of law has no discretion in the matter. See the case of Adekoya versus Federal Housing Authority. See also the case of Egbe versus Ade Parasi. See also the case of APM versus INEC. In the case of Power Product International Limited versus Wema Bank, the Court of Appeal Lagos Division has this to say: in law time begin to run when there is in existence not only a person who can sue and another who can be sued, but also facts must have happened when which are materials to be proved to entitle claimant to succeed. See also the decision of the Supreme Court in the case of Omnia versus Dika Trade. The claimant in this case has stated that in April 2009, based on a complaint by the defendant regarding allegation of fraud, police officers came and arrested him. He was detained and interrogated by the police about some allegation of fraud, but he was neither queried nor asked to explain his role by the defendant. He was rearrested after his release by the claimant. Upon his second release from custody of the police on 24th day of April 2009, he was suspended from work and subsequently dismissed from service by the Exhibit G, letter dated 29th day of June 2009. Subsequently, he was charged before the Federal High Court, but he was discharged and acquitted as per Exhibit H. The parties in this case are at idem that claimant's dismissal, which he is challenging by this suit, was terminated on was determined on 29th day of May, 29th of June 2020, 2009. In the circumstances, times begin to run for the purpose of limitation from 29th day of June 2009 to 31st day of October 2025. By way of arithmetical calculation, as at 31st day of October 2022, when this suit was instituted, 2025, when this suit was instituted, it is a period of 16 years, 1 month. When this suit was instituted was a period of 16 years and 1 month. This means the claimant's action is caught by Section 60 of the Cross River State Limitation Law, as he did not commence his suit within the 5 years allowed by the law. However, reliefs 1 to 16, 20 to 21, 24 to 25, having been predicated or wrongful dismissal, are all caught by the reliefs by Section 16 of the Limitation Law. The reason being that this action was filed after the 5 years window has passed. The suit becomes statute bar, and the court loses jurisdiction to hear the merit of the dispute on wrongful dismissal of claimant from the employment of the defendant. For relief 17, 18, 19, and 23, they are on pension and gratuity. These reliefs, the law is well settled that pension and gratuity are immune to limitation law or period of limitation. See the case of Ogbeche versus NNPC. Also, Section 173, 2001 of the 1999 Constitution as amended. The Court of Appeal decision in Ogbeche's case was clear after reviewing the constitutional provisions, and other decided authorities came to the conclusion that no claim on pension and gratuity shall be invalidated merely because the claimant failed to present his claim within the specified period of time, if any. The court has held that payment of pension and gratuity is not a bounty to the employee by the employer. It is a right of an employee to claim pension and gratuity. The amount should be disbursed without delay, and where payment is delayed, the employer cannot challenge the employee's claim for payment of pension and gratuity on ground of limitation period. In abidance to the settled position of the law on pension and gratuity, I have no choice than to come to the conclusion that reliefs predicated on pension and gratuity in this case cannot be affected by the provision of Section 16 of the Limitation Law. Now, the next issue to be considered is claimant's argument that even if his case was statute bar or affected by the limitation law, his suit is still maintainable because it falls within the exception to the limitation, as this suit is that of continuance of damage or injury. Having satisfied that the instant case is so far as it relates to issue of wrongful dismissal, payment of salaries, as have been caught up by limitation law, the next step would be to ascertain whether the matter has come within permitted exception to the limitation law, that injury in question is a continuous injury. The exception on continuance of injury was provided for in the Public Officers Protection Law of Cross River State, and not in the Cross River State Limitation Law. Even if it has been provided, it will not apply in this case. In the sense that for continuing injury, to be applied, and the employee must be in employment, for otherwise the claim that the deprivation continues would not stand. In the instant case, the claimant ceased to be in office in 2009. There is therefore no question as to the existence of deprivation of an entitlement which comes in periodically and has not ceased after 2009. And there is no evidence to show that there are other determination of his employment by the claimant subsequently after 2009. This being the case, the claimant in the instant case cannot claim the benefit of exception to continuing injury, as there is no such continuing of injury in this case. In any event, the definition of the phrase continuance of injury by case law authorities was continuance of the act which caused the injury and not the injury itself. I find and hold that in the instant case, the claimant's claim cannot be a bail of the exception of continuous injury, as he is no longer in the employment, and therefore the question as to existence of an entitlement which comes periodically and has not ceased after 2009 is untenable. In the instant case, the claimant has never ever been paid the monthly salary, so the issue of continuance is not tenable. The claimant has heavily relied on Section 31, subsection C of the Cross River State Limitation Law to argue that his case is that it has also come within the exception to Section 31 as provided in the limitation law. That is, it is affected by mistakes. For proper appreciation, I hereby reproduce the provisions of Section 31. It provides, subsection 1, subject to subsection D, where in the case of any action for which a period of limitation is prescribed by this law, either C, the action is for relief from the consequences of a mistake, a period of limitation shall not begin to run until plaintiff has discovered the fraud, concealment, or mistake, as the case may be, or could with reasonable diligence have discovered it. I do not see how claimant's dismissal can be termed mistaken. There is nothing before the court to show that the dismissal was an unintentional error or done by accident, since the claimant has not shown that the action decisions of the defendant in dismissing him from the service was based on judgment that produces an unwanted or unintentional result. He cannot rely on mistake to have limitation law suspended or postponed. In this case, the clock can only be suspended or forced if there is actual discovery of mistake, which is absent in the case at hand. Therefore, the clock, for purposes of time limitation of law, in this case has not forced. There is nothing shown by the claimant to establish that his action was built upon a fundamental mistake of facts or law to warrant finding that the limitation period will only begin once the mistake is discovered. The claimant has a duty to show both parties operated under a critical hidden error that obscure the right to sue until its discovery. In this case, the claimant was fully aware he was dismissed on 29th day of June 2009. Therefore, the course of action was clear and visible and started running on the day of dismissal. The decision of the claimant to wait for the conclusion of criminal trial is a choice of convenience, not based on any legal disability caused by the defendant's concealment on the ground or mistakes, to ground reliance on any mistake. From all I have been saying above, the claimant has not convinced this court that his case comes within the exception provided in Section 31(1)(c) of the Cross River State Limitation Law for him to benefit and have his course of action forced from running for the purpose of limitation. Having found out that all the reliefs in respect of wrongful dismissal and ancillary reliefs connected to wrongful dismissal have been caught by Section 16 of the limitation law, I shall now proceed to consider the merit of the reliefs respecting the pension and gratuity, since they are immune to limitation law. In relief 17, 18, and 19, the claimant is claiming payment of the sum of 79,285,803 naira 3 kobo as special damages. The said sum representing accumulated retirement savings pension fund entitlement for 16 years counting calculating from 2009 to 2025, subject to further adjustment upon the production of document on salary review exercise done by the defendant between 2009 and 2025, including interest which claimant would have earned if the defendant had not wrongfully dismissed the claimant from his employment. In the alternative, the sum of 13 million is claiming the sum of 13,891,735 naira 68 kobo as special damages. The said represents the accumulated retirement savings pension funded entitlement of the claimant from 2009 to 2025, which claimant would have been entitled to if defendant had not wrongfully dismissed him from the contract of employment and subject to further adjustment upon the production. I note reliefs 17 and 18 are same. They are claiming one and the same thing. So I consider them as one and same relief, while relief 19 stand as an alternative relief to relief 17 and 18. In line with the settled principle of law, I shall first consider the main reliefs on pension. If it is established, it will grant and granted, but if it is not proved, I then consider the alternative relief. Let me make it very clear that a claim for payment of pension contribution being monetary in nature is generally considered a claim for special damages. Special damages are those losses that are unquantifiable, quantifiable, ascertainable, and directly attributable to the breach of contract or duty. Unlike general damages, which are presumed to flow from wrong and left to the discretion of the court, special damages must be specifically pleaded, particularized, and strictly proved by the claimant. The classification and principles governing special damages are primarily established and reinforced by judicial pronouncement from the Supreme Court, particularly by the Court of Appeal and the Supreme Court. These courts have consistently held that any claim for a specific quantifiable financial loss must be treated as a special damages. See the case of NECA BB and Manufacturing Company Limited versus ACB Limited. See also the case of Arison Trading and Engineering Company Limited versus Military Governor of Ogun State. These cases, in these cases, both emphasize the duty on claimant who claims special damages to prove it strictly. These cases establish the fundamental principle that special damages are not awarded on mere conjecture, but on concrete evidence. See also GT Bank PLC versus Mokpon Technologies, which provides guidance on how to plead and prove special damages, reiterating the necessity for specific pleadings and strict proof. The case of Ogwejopo and another versus Ubakason Limited further clarifies the instance at which claimant is said to have discharged the onus of proving special damages, reinforcing the high standard of proof required. For the claimant to prove a claim for unpaid pension contribution, as with any claim for special damages, requires meticulous attention to pleading and evidence. The claimant must satisfy the court on two main fronts: the entitlement to the contribution and also exact amount due. This means the claimant must specifically plead the claim for unpaid pension contribution in the statement of fact. This involves stating the precise amount claimed and providing the particulars of how the amount is was arrived at. For instance, the claimant should specify the period for which contributions were made, the amount, monthly and or annual salary on which the contributions were to be based, and the applicable percentage rate contribution. Failure to specify pleading specifically damage will result in the court not awarding them, even if there is evidence to support the claim, as held in GT Bank PLC versus Mopcom. The burden of proof lies squarely on the claimant. He must adduce credible and cogent evidence to substantiate every item of the special damages claim. This typically involve documentary evidence such as including pension contribution, pay slips showing deductions or lack of deduction thereof, statement from the pension fund administrators indicating contribution received. If the claimant involves interest, the basis for calculating such interest must also be provided. The claimant is also to give oral testimony to explain the document and the circumstances surrounding the payment. The claimant must present a clear calculation of the total amount owed. This is not merely stating a figure, but demonstrating how that figure was arrived at. For example, if the contribution rate is 8% of basic salary, housing and transport allowances, the claimant must show the monthly sums of this component and the 8% calculation of each of the months. The strict proof for special damages means that the evidence must be direct, specific, and leave no one in doubt as to its cogency. As established in NECA BB Manufacturing Company Limited versus ACB Limited and Arisen Trading Company versus Military Governor of Ogun State, the claimant must prove not only that he suffered the loss, but also the exact amount that he lost. If the evidence presented is clear, cogent, and unchallenged by the defendant, the court will accept it as sufficient proof. Therefore, for the claimant to be granted his relief on pension, he must discharge the onus with concrete, credible evidence, with contrary and credible evidence. Since the claim is monetary in nature, it falls within the species of relief termed as special damages by law, must be specifically pleaded, particularized, and proved strictly. Exhibit M, Employee Handbook, which claimant relied heavily for his claim to pension, made reference to clause 13.22, where it says the bank operates a contributory pension scheme for staff in line with the Pension Reform Act, now Pension Reform Act 2014, by the provision of Section 4 of the Pension Reform Act, which governs the contribution for the contribution pension scheme in Nigeria. It requires a minimum total contribution of 18% of an employee's monthly emolument, split into 10% by the employer and 8% by the employee. According to the claimant, upon being employed, he provided his pension funds savings account for his pension contribution to be remitted directly, while the dependent also required to contribute equal sum of 36,176 naira 395 kobo. I note Section 4 of the Pension Reform Act provided for 10 and 8% contribution from the pleadings and evidence. It is clear to me in the witness statement of and witness statement of both. The claimant multiplied what he claimed to be his monthly pension by 12 and then multiplied by 16 years, arriving at the sum of 13,891 naira 735,100 naira 68 kobo as his pension entitlement for 16 years from 2009 to 2005. When this suit was commenced with interest added, the amount became 79,285,803 naira 3 kobo as per paragraph 43 and 47 of the statement of claim and 44 to 48 of the statement of defense. I have examined exhibit N and O. There is nothing in this exhibit which were in respect of claimant's pension remittance where the sum of 36,000 were remitted as claimant's pension contribution or deduction from his salary. Therefore, there is also equally no any entry of 36,176 remitted as dependent's contribution to claimant pension fund with IBTC pension managers. The claimant failed to tender relevant evidence that will assist the court in regards to his salary and amount due. The claimant's failure to tender his pay slip is fatal to his case, as pay slip will itemize what the claimant is entitled to as his salary, what was deducted as pension, tax deductions, and any other deductions allowed by law will be borne out by the What is even more surprising is that the claim of the claimant on pension was for period when claimant was not in employment, i.e. 2009 to 2005. By the Exhibit C, claimant's employment with the dependent was ended by the Exhibit G, claimant's employment was ended by dismissal. This means claimant by operation of law is no longer employee to be entitled to earning pension contribution from the dependent as he was no longer employee of the dependent. This position remains even where the dismissal was wrongful, as the law is that master and servant relationship dismissal, whether wrongful or not, has ended the relationship since there is no longer employment relationships between the claimant and the dependent as from 2019, as from 26 June 2009, the claimant is not entitled to any pension as per his employment with the dependent. This is because even where employer ended the employee's service in breach of terms of the contract of employment, the only remedy available for employee is not entitled to any pension as per the employment with the dependent. This is because even where employer ended his employee's service in breach of terms of the conditions of employment, he cannot be ordered to be reinstated. The only remedy often available is to seek for payment of it is wrongful to but certainly not null and void. The contract of employment was wrongful but not null and void. The only remedy is damages. A court will not foist on employer and employee. See Adebayo Sunday versus Joseph versus Kwara Polytechnic. Thus, an employee whose employment has been dispensed with by his employer cannot claim for pension when he is no longer on salary, as he was no longer on service. The claimant pension contribution it is to be noted that a relationship of master and servant, parties are at liberty to enter and exit the relationship as well. Parties are at liberty to enter and exit the relationship with rules, the relationship at which without let or hindrance. See the case of Obot versus CBN, see also Kato versus CBN, and Idonoboy Obu versus NNPC. It is clear to me claimant has not proved entitlement to payment of pension from 2009 to 2005 when he was no longer in service of the defendant. Even if court had found the dismissal to be wrongful, it will not change anything regarding pension regarding the pension, as court is not permitted to order reinstatement in cases of master and servant. In view of the foregoing and reason given above, I hereby dismiss reliefs 17 and 18 for failure of claimant to prove entitlement to same. I now move to reliefs 22 and 23, which are for gratuity. The claimant in claiming the sum of 121,951,785 naira 6 kobo as gratuity from 2007 to 2025 if claimant for 18 years. See paragraphs 55 to 60 of the statement of facts and paragraphs 56 to 61 of the witness statement on oath. It is clear from the pleading and evidence that claimant's claim included period when he was not in service of the claimant. The claimant stated that the amount being claimed is what he would have earned as what he would have earned and entitled to if not because of his dismissal. Gratuity is an entitlement which is granted by terms and conditions of service. The claimant places reliance on Exhibit M, Staff Handbook. He specifically relied on clause 13.21112. The provisions of clause 313.21.1 on gratuity and pension read, as a staff of Sterling Bank, you may benefit from bank's non-contributory gratuity scheme. In order to be eligible for gratuity, you would have spent a minimum of 5 years in the bank's employment. Your gratuity payment would be computed on the basis of your total monthly emolument. 3, you will, however, not be entitled to any gratuity benefit if one is dismissed from service or if one resign in order to preempt dismissal. Further clause 13.334 Exhibit M on summary dismissal provide 1. Fraud, attempted fraud, and other forms of gross misconduct could could earn an employee a summary dismissal from bank employment. It is clear from the above provisions of employee handbook that for an employee to be entitled, for an employee of the dependent to be entitled to gratuity, he must have served the dependent for not less than 5 years. And if the employee was summarily dismissed, he forfeited any gratuity no matter the number of years served. In this case, from the evidence before the court, the claimant served from 2007 to 29th day of June 2009 when he was dismissed from service. This clearly shows that his service was less than 3 years. He served the defendant in less than 3 years. In the circumstances, he is not entitled to any gratuity. Even if claimant has served for the minimum period of 5 years, to qualify for gratuity, his dismissal as per Exhibit C, Exhibit G has deprived entitlement to has deprived him of the entitlement to gratuity. In this case, the claimant claiming for gratuity despite being dismissed from service seems to be claiming that his services are still continuous despite the dismissal. The law as regard master servant is very clear that once an employee is dismissed or have an employee is dismissed or have his contract of service terminated, his dismissal, termination, even if wrongful, will not make the contract to be subsistent. This means that even where court found dismissal wrongful, claimant cannot be allowed to treat his employment as if it did not happen. This means the claimant service has ended on 29th day of June 2009 by the XBG, and by arithmetical calculation from that 2007 to 2019 is not up to 5 years to make him eligible for gratuity. Therefore, claimant claim for gratuity failed, same is hereby dismissed. As once employee is dismissed, he lost right to gratuity, if any. As once employee is dismissed, he lost his right to gratuity. It is only those who have ceased to be employees on ground of voluntary resignation, voluntary retirement, redundancy, or an attainment of retirement age, or compulsorily retired that can be eligible for gratuity. Therefore, the claimant, having been dismissed from service of as per XBG, is not entitled to any gratuity payment. In the circumstances, relief 22 and 23 equally fail, and same are hereby dismissed. From the foregoing, the claim of the claimant failed as per the reliefs or wrongful dismissal payment of special damages predicated on what would have been earned if not because of wrongful dismissal have been caught by section 16 of the Cross River State Limitation Law. In those reliefs which I have earlier identified and enumerated in this judgment are hereby dismissed for being statute barred. The reliefs bordering on pension and gratuity have equally failed on the merit, they are hereby equally dismissed, and the entire case of the claimant failed, and same is hereby dismissed. The above findings have ended the life of this suit. However, this court, being court of first instance, is duty bound to proceed to consider the merit of the reliefs sought by the limitation law. In case there is an appeal before the Court of Appeal, the Court of Appeal will have the benefit of having the views of this court and thereby eliminate the necessity of ordering retrial. The reliefs are reliefs 1 to 16, 20 to 21, 24 to 24 have been predicated. These reliefs have been predicated or wrongful dismissal. They therefore fail and caught by section 16. I shall start consideration of the merit of the remaining reliefs before the court by considering reliefs 1, 2, 3, 4, 5, 6, 7, and 8 by 20, 21, 24, 25, 26, and 26. I shall start considering on merit these reliefs. The law is tried in a claim for declaratory, a claim for declaration, a claim for declaratory reliefs. The claimant must prove his entitlement thereto by cogent and credible evidence. He must rely on the strength of his own case and not on the weakness of the defense, if any. Indeed, a declaratory relief will not be granted on the basis of admission by the adverse party. See the case of Dumes, Nigeria Limited versus Nwakoba. See the case of Bello versus Ueka. See the case of Emenike versus PDP, and Motomi versus Dada, Mohammed versus Mako. The claimant case is built around wrongful dismissal. According to the claimant, he was alleged to have been involved in fraud against the defendant. Consequently, the defendant reported him to the police, who arrested him and detained him and released him on bail. But the police officers from headquarters came and arrested the claimant. He was issued with suspension letter and letter of dismissal. The claimant case is built around wrongful dismissal. According to the claimant, he was alleged to have been involved in fraud. That's why he was reported to the police by the defendant. He was arrested. Upon his release, he was issued letter of suspension, and thereafter he was dismissed and he was charged to the court, but he was discharged and acquitted as per Exhibit H. The suspension and dismissal were without any query issued to the claimant or appearing before the disciplinary committee as provided by in Exhibit M. The defendant on their part sought to impugn Exhibit M on the ground that it was not signed by the claimant, so he cannot rely on that exhibit. Exhibit M cannot be relied by the claimant. I have given a deep consideration to the arguments of parties on the efficacy of Exhibit M. It is to my mind, it is my view that Exhibit M, being staff handbook which defendant had not denied, is applicable to the claim of the claimant notwithstanding the signing by the claimant. The objection of the defendant to Exhibit M cannot hold water when the claimant has admitted a claimant's being her employee, her former employee. The defendant did not also object to Exhibit M when it was tendered in evidence. The defendant seems to have misconceived Exhibit M in that it is not a contract of employment between the claimant and the defendant. Exhibit M is a term and conditions of service for all employees of the defendant. It is not special term. Furthermore, Exhibit M is a condition of service and not the main contract of employment. Exhibit A is the contract of employment which was accepted by the claimant. Exhibit A, letter of employment, is the basis of the relationship between the claimant and the defendant and not the conditions of service. The claimant grouse in this case is that he was summarily dismissed without query or hearing. This has violated his right to be heard before he was dismissed. The defendant has not adduced any evidence to show claimant was queried or given opportunity to defend himself for the allegation leveled against him, based on which he was dismissed. The law is tried both in employment and statutory labor or in matters servant relationship. Employer has the unfettered right to discipline his employee by way of summary dismissal. However, the justification for summary dismissal of the employer defendant However, for justification for summary dismissal, employer in this case must show that the servant claimant in this case was given opportunity to react to the allegation against him, i.e., employer must comply with the doctrine of natural justice or the Altram pattern. See the case of ZD versus River State Civil Service Commission. In the case at hand, the claimant was issued with XBG without issuing him with a query or hearing that is giving him opportunity to exonerate himself. The failure by the defendant to query or make claimant appear before the disciplinary committee has rendered the dismissal of the claimant wrongful. However, the finding does not mean that the claimant cannot However, this finding does not mean that the claimant employment remains intact or subsisting. The dismissal, though wrongful, has ended the relationship and the claimant remedy is in damages. See Kado versus CBN. See also Skybank PLC versus Adebu, which was also relied upon by the claimant. The finding that claimant's employment was wrongfully dismissed goes to establish that the report made to CBN for blacklisting of the claimant based on claimant's wrongful dismissal cannot stand. The defendant is hereby ordered to withdraw the said letter sent to the CBN. However, since the employment of the claimant is in the eye of the law, dismissal despite being declared wrongful. The claimant cannot be granted an order for mandating the defendant to withdraw same as the remedy available for wrongful dismissal is for damages. The claimant is also not entitled to an order for the defendant to accept his letter of resignation. The reason being that in master and servant relationship, parties are court cannot twist defendant on its choice of way to end the relationship. The path taken by the defendant has consequences, and that is payment of damages. Reliefs 16, 13, and 14 are not grantable because they are claims for period claimant did not serve the defendant. The claimant, by making this claim, is in a way saying that he is still in service of the defendant, which is not the case, as the defendant has ceased to be employee since 29th day of June 2006, with Exhibit G later dismissing the claimant from service. The reliefs 15 and 16 are for status quo. Clause 13.5.1 of Exhibit M provide regarding status quo. On separation, on separation, the bank employment, on separation from the bank's employment, the bank reserves the right to sell your official status card to you. This will be sold at the higher or net value book, and by on separation. 2. On separation from the bank reserves the right to sell your status card to you. This will be sold at the higher net book value of the vehicle or 10% cost. It is executive management prerogative to consider any request for discounts. 2. However, in the case of summary dismissal, you will not be eligible for sale option. 3. Installing bank cards are amortized over a period of 4 years. Ownership of the car will automatically revert to you if you remain in the bank's employment for the duration of the amortization at 10% of the original cost. It is clear from the above lucid provisions of employee handbook that status quo is only an entitlement when employee is still in service of the defendant. But when there is separation, the defendant reserves the right to sell the said car to the employee at higher or net book value of the said vehicle or at 10% of its cost, and the employee must apply to buy the said car for the management to consider and give approval. Therefore, the status quo is not an entitlement that an employee can claim to be entitled to. The claimant has woefully failed to prove entitlement to grant of reliefs 15 and 16. They are hereby refused. Reliefs 24 and 25 are for general damages and aggravated damages. I have thoroughly considered the facts of this case and the submissions of counsel for the parties. As pointed out earlier in this judgment, where there is finding of wrongful dismissal, employee would be entitled to damages, which is salary in lieu of notice for period of notice, while Exhibit A and Exhibit M are to the effect that either party has the right to end the relationship by giving 1 month's notice or payment of 1 month's salary in lieu of notice. The claimant is therefore entitled to be paid 1 month's salary in lieu of notice for the wrongful dismissal. On the other claims for damages and aggravated damages. I have considered the principles laid down in Skybank versus Adegun, which claimant relied heavily in supporting his claim. The claimant is therefore entitled to be paid as I have carefully considered the principle laid down in Skybank versus Adigun, as well as Exhibit H, which clearly shows that the discharge and acquittal of the claimant was not based on full-blown trial in the circumstances. I hereby award the sum of 1 million naira damages to the claimant. Let me say here that the earlier dismissal of this case based on statute bar and merit consideration of the reliefs on gratuity, pension and gratuity still stands. The subsequent consideration and finding which resulted in granting damages to the claimant and 1 month salary in lieu of notice was done in abidance by the admonition of the Supreme Court and the Court of Appeal. Regarding determination of substantive issues, when court found out that a matter, it has no jurisdiction to entertain a matter, the court should proceed to consider merit of the case so as to give appellate court benefit of having its views. Therefore, and thereby avoiding the appellate court ordering retrial, which will be another waste of further precious time in dealing with the case. See the case of Pabumi versus University of Ibadan, and also the case of C Trucks Limited versus Spain. Before closing the chapters of this case, let me say that it is highly disturbing and astounding the practice whereby counsel will cite a case without supplying the necessary citation to enable the court verify the authenticity. The defendant has raised concern about the case cited by the claimant, which has no citation. I have also searched for the case but could not lay my hand in any of the known reports that are available to me. In the circumstances, counsel shall ensure whenever filing his process in court or his addresses that cases cited are with clear cases relied on are with clear citations so as to allow the court to verify on the authenticity of those cases. I deliberately failed to make reference to the argument of counsel for the claimant regarding the evidence of DW1. The reason why I was mute on it was the law is very clear and unambiguous that he who asserts must prove. It is only after the claimant must have established his case that the defendant will be required to call for evidence, or that the court will now consider the evidence of the defendant when the claimant has established his case. From all I have been saying, the claimant woefully failed to establish his case. In this case, as some of the reliefs were affected by statute of limitation, while the remainings he failed woefully to establish by evidence that he is entitled to those reliefs. The case of the claimant is hereby dismissed. I make no order as to cost, parties to bear their respective costs. Judgment is hereby entered accordingly.
As court pleases. My Lord, we quite appreciate the industry and the details my Lord has given in this matter. It's beyond expectation. We thank you, my Lord.
You're welcome.
Yes,
Lord, we also join our voice to thank you for the industry.
You are welcome.
Yes.
You are welcome.
Thank you.
Registrar, any other matter?
No, that's all for today.
I thank you very much, Counsel. I wish you successful and enjoyable vacation.
My Lord, and you too.
Okay, we have come to the end of the
wonderful
virtual.
actually.
Thank you. Thank you.